Hi, Shanae. Good day, guys. I think we can start. I think the other guys can join us later just for the sake of time so that we don't go over the allocated time. Also, thinking it might be a last session for today. So just to confirm how we'll proceed, so I'll have my presentation up and then I will start and just follow the pattern that is also in the study guide, so you can get out the study guide in the meantime. I am also pasting the link to the attendance register. I'm actually don't know. I actually don't know why I'm getting this error, because this was with the previous session as well, where I tried to paste the attendance register, and it did not allow me. Let me just check something quickly. Yeah, I actually don't know why it doesn't allow me, but I'll just keep on trying to paste the link to the attendance register, hopefully. Okay, now I think let's continue. I'll just try to paste the link again to the attendance register. I'll share my screen. Oh, and just apologies to start about a few minutes later. We're just waiting for the other guys to join in. So just to confirm, it's AUE1601. Just as a reminder to please switch off your video, to mute your mic. I will attempt to paste the link to the attendance register in the feedback form during the session. And then also I will, if you've got any study support related queries, you can send an email to ctntat@unisa.ac.za. And then what we'll be covering today is announcements from the lecturer. We'll recap the previous session, our to-do list, and then we will complete topic 3 from 3.1.6 to governance of companies, and then we will do topic 4, which is directors. Just on the announcements from the lecturer, so number 1 is to work hard on assignment 2 and submit it in time. Not only does the marks count towards the year mark, but it serves as a valuable exam prep. Students need to refer to my UNISA for announcements, resources, and FAQs. Students need to make use of their e-tutors if they have questions or queries, as they have been allocated to e-tutor groups on my UNISA. So specifically with the last point there regarding e-tutors, they are the ones who offer assistance on the activities that are in the study guide. So you're more than welcome to check on my UNISA to which group you belong to, and then you can ask or do those activities from there. As much as I do touch a little bit on them, but there is someone specifically responsible for that. Also, one other announcement, actually two announcements that I also received, just maybe to note them as well, that number one, regarding assignment one, the due date to submit the assignment has been extended to the 22nd of September. So if you had not submitted assignment, you do have time to submit that assignment. And then any assignment that is due or that was due, that would be assignment two in your case, it is still due on the 29th of September. So you basically have a week, if you submit assignment one on the 22nd, you'd have a week to submit assignment two. Also, the other one was regarding the October or November exams. So the university is still in talks on how to go about in having the exams for the October or November period. But communication will be sent out during the course of time, to confirm, how things will be done, if it's still going to be online or if needed be, you have to attend the campus, but that will be communicated in due time. Also, I did manage to get the lecturer to come in our next session, which will be on the 3rd of October. The lecturer is Adol Priya, so she will be joining us. And if you do have any specific questions for her, let's say, for example, how will the exams be based? Is it going to be multiple choice, short questions, or essays? Just get those questions ready for her. As I said, she'll be joining us in our next section on the 3rd of October. Just to recap on the previous sessions, if there are any questions before I start recapping on the previous session? Okay, so I'll assume that there are no questions. So last week we looked at capitalization of profit companies. We also went through the CIPC website and we looked at the prospectus for Sasol Inzalo and Phumelele shares, or the prospectus for Phumelele. So looking at the capitalization of profit shares, we looked at the types of shares that a company has, when do they distribute the shares, what is the process, to distribute those shares. For example, it first needs to be authorized. The directors need to sign that off. What are the implications if the directors authorize shares, but the board is not agreed on? But part of that section, we will complete it today. So don't worry too much about it if you can't remember everything. We also looked, as I said, to the CIPC website, generally, for you guys to have a feel of, how it is, what is needed to register a company. But there was a question that was asked, why must you file? And I just had problems in opening the FAQ for the CIPC, but I did manage to get that. I'm just trying to open it up now. I think it was Tebe who asked, why must you file? And this is the answer. So what is the purpose of filing a company or close corporation annual return? All companies, excluding external companies and close corporations, are required by law to file their annual returns with the CIPC on an annual basis within a prescribed time period. The purpose for the filing of such annual returns is to confirm whether a company or close corporation is still in business or trading, or if it will be in business in the near future. Therefore, if the annual returns are not filed within the prescribed time period, the assumption is that the company or close corporation is inactive, and as such, CIPC will start the deregistration process to remove the company or close corporation from its active records. The legal effect of the deregistration process is that the juristic personality is withdrawn and the company or close corporation ceases to exist. So if you do remember when I said that part of my ones, they had initiated the deregistration process. However, was able to file my annual return, and that process was stopped, because I had filed it, and then obviously I had to pay a fine. Normally, I think the fee is 100 rand just to do or to file the annual return, but I had to pay an extra fee to because I was late. So that was just the consequence of it. And also, what I did is with this document, if you can allow me, what I'd also done is I had or actually I'm gonna do it a bit later. So what I did is when you go onto on my UNISA under this module code, where for example you will see the recordings. Also there is a tab there that says notes folder. If you click on the notes folder there, I have created I created a folder specific to that session. Like for example, last week's session, I have included the CIPC FAQ annual return document. So if you click on that folder within this module, you will see this module or this document. I've saved it there. Also for session one, where I've got the Companies Act and the regulation to the Companies Act, I've saved those two documents under AUE1601 under the session one folder. I will go through it, hopefully, if I do get a chance to go through the website just to show you where it is. I also did save the two prospectus for Sasol and the Pumelele shares. As I said, just as a reference point, if you may be going through the recordings again and you want to make reference to what I spoke about when I was going through the prospectus. Okay. So our to-do list, there were two questions before. There were two questions that were actually that are posed. What are preferences? And also the second one, what is an indirect vehicle of investing in shares? So I'll quickly open those two links. So the first link is I got the information from the JSE, which is a reputable institution, rather than just getting it from Investopedia or someone who has just written notes on it. So I tried to make sure that it's credible and reputable information. Just wait for my Google to open. Okay, let's restore. Okay, hasn't opened. Let me check here. I'll open this side. Okay, while it's loading there. Okay, there is it. Okay, so the question was what are preferences? So this was in relation when I asked we had said that preference shareholders get preference when dividends are paid and also at liquidation, but then we asked when exactly do they become preference? So here's our answer. So it says here, preference shares are really debt instruments. These shareholders have lent money to the company. In return, they get the first bite of the profits in the form of preference share dividends. The rate is usually linked to the prime rate. If the company is going bankrupt, preference shareholders will be paid out ahead of ordinary shareholders. So just to recap, preference shareholders, when do they get paid? When a company is declaring dividends or at liquidation stage, they are the first people to, or the first shareholders to receive, a payout, either a dividend in the form of profit, or in a case of liquidation, any amounts that will be due to the shareholders when regarding liquidation. So basically, they are the ones first get paid, with other creditors, and then obviously whatever will be left behind will be paid to the ordinary shareholders. And then the second question, when we spoke about investing, we said that when you buy a portion of or a unit of a company, you are basically, you know, buying a unit, you are a part shareholder of that company. And then I asked, what is an indirect way of investing in shares? And part one, or actually one of the solutions, is investing in what we call unit trusts. So this is just an example. So I searched for, so this is a Coronation Balance Fund, South African fund investing in the multi-assets, specifically high equity. And remember, this is just an example to validate the question that I asked, what is an indirect way of investing in shares? And this is meant for maximizing long-term returns for retirement savers. This is just part of, how they, come up with an investment objective. But where I want to go to directly, so for example, with this fund, it was launched on the 15th of April in 96. Currently, the fund size is 82.14 billion. The number of shares, this is about 1.9 billion number of shares or units. So currently, this number of units, based on this NAV, which is the price per unit, it's currently sitting at 82.4 billion. Now, specifically looking at where these shares are bought, or where the 82.4 billion is invested in, I'll make mention of companies that I think we are aware of. So out of that 1.9 billion shares, 6.1% is invested in Naspers. 3% is invested in Anglo American PLC. So what does this mean? So if, for example, Anglo American is not offering shares to the public, but I want to invest in those shares, or I want to invest in that company, I can invest via a unit trust. In this instance, where I can go to Coronation, I find out, oh, okay, for this specific fund, they are investing in Anglo American, as you see there. Then I can, invest according to their amounts that you can invest in, minimum amounts. I can invest there, and then I can have a small portion, of Anglo American. And when we talk about diversification, this is what we mean, where you are investing in generally in more than one company. Or it could even be a property company. You are investing in more than one. Also talking about not putting your eggs in one basket. Let's say, for example, instead of you having to invest in Sasol and Eskom and Telkom and SAA, but you can invest in funds that collectively invest in those funds, also just like with other companies as well. But basically, this is an indirect way of buying a piece or a unit or a share in a company via unit trusts. I don't know if there's a question specifically to those two examples before we proceed. Let me see here if there's any question. Okay, let me see if there's a question here before I proceed. Okay, let me look for the message here. I've also got this open here on my side so that it's easier when I need to, when there's a question asked. Okay, Tandeka. Okay, so I think what you need to do, as I alluded to earlier, you need to send an email. I'll show the email address now so that you can write it down, just to let them know that you aren't receiving any communication or announcements regarding this module, and then they can assist you so that you can have, access to the material. I'll just show the email address again now. So the email address you need to email to, I'll show it. It's this one here, ctntart@unisa.ac.za. So you just send them an email and state your case that you do not have access to the material or the announcements, and then they'll be able to direct you to the respective department if needs be. But you need to send an email to that email address. Thank you. Okay, going to our to-do list. So I've covered those two, and if I remember correctly, those were the two instances or two questions that are posed in the last session that we needed to do some digging on. But basically, going to finishing off last week's session, which was shareholders and shares, we will now look at page 32 of the study guide. If you can turn to page 32 of the study guide, where we are going to talk about the distributions to be authorized by the board. Before we touch on the last unit, which is governance of companies. I will start so long. Page 32 of the study guide, 3.1.6, distributions to be authorized by the board. So basically what that section says there is, number one, the board needs to authorize the distribution of shares. A company cannot just have shares, offered to the public without the board signing it off. There is a process they need to follow. If it would so happen that they did not follow the whole process and shares were issued to the public, those shares issued to the public will become void, or those contracts, remember, this would be a contract where you as a shareholder saying that you've invested X amount of money to the company, and the company is confirming that yes, you have invested X amount of money, and as a result we have given you X number of shares. So that is basically would be a contract. So that contract in that instance will be null and void, and then those directors who were responsible for that issuance of shares without it being signed off would be jointly and severally liable for the debts incurred out of that issuing of shares. But we'll look at diagram 3.16 to actually give more information on that. One thing to note in that introductory or that introduction to this section is as a shareholder, when you receive profits, since you are investing in a company, the form of profits that you would receive is dividends. So you will hear that a company has declared a dividend of let's say 2 rand, per share. Basically, what that means is if you hold a share, you'll be paid 2 rands for it. This would be from the profits that the company would have made, but it is declared as dividends. That is confirmed in that page below of 32, where it says it is important to note that distributions include payments for share buyback. That is where a company buys back its own shares, and the payment of dividends. And the dividends is a portion of a company's earnings which is distributed to its shareholders. Also dependent on the company, they can declare dividends quarterly, biannually, or annually, depending on what the memorandum of incorporation says. Also dependent on whether the company would have made a profit in that period where they want to declare the dividends. But looking at diagram 3.16 on distribution, which is actually explained just above that. So it says here, for a distribution, is it pursuant to an existing legal obligation or court order, and is the distribution authorized by a resolution? If so, the solvency or liquidity test must be satisfied and acknowledged by the board, repeated if distribution is not completed within 120 days. So basically what it says is that the solvency and the liquidity test must be done when the distribution or the issuing of shares is done. it must satisfy the solvency and liquidity shares. If you remember previously, we said that you need to know the moment you issue those shares, are you still solvent? Are you still liquid? It further on goes to say, if the solvency and the liquidity test have not been satisfied and the distribution is not completed within 120 days, that solvency and liquidity test must be repeated. So this is basically saying that, let's say today you are issuing shares, you've done the solvency and the liquidity test, and you pass those two tests. However, the issuing of shares was a period, let's say, for example, of 2 months. But for some reason, that process has not completed and the board has signed off to an extra 2 months of the issuing of those shares. Now, what this says is under distribution under Section 46 is that if at after the first date of the issuing of shares, if it's 120 days and that process has not been completed, then the company needs to redo the solvency and the liquidity test. And if you think about it, this would be more on, look, 3 months would generally be a long period, when a company is operating. So you would still want to confirm that you are still, satisfying the solvency and the liquidity tests. And then it says here, if these requirements of Section 46 are not adhered to, then the directors will be held liable for the losses the company incurred. That is, they are jointly and severally liable. They are personally liable, jointly and severally, for the debts incurred by the company, and the transaction will be void. Now, remember, this is in relation to the shares or to the issuing of the shares. If it so happens that the company, at the very same time, they were signing a contract to mine in for oil extraction in Saudi Arabia, and that is not going well, then it is another case. But this one is specific to the distribution of shares. Those directors that would not have adhered to Section 46 of the distribution of those shares, they'll be personally held liable, jointly and severally liable for the losses the company incurred. Let's say, for example, this would be a case of where now, remember, when we did the previous session where it said that once the contract is null and void, we need to repay those shareholders with interest. So if in an instance where interest needs to be paid, those interests will need to be paid by the directors personally, jointly, and severally. And as I said, that transaction or the contracts of those distribution of shares will be void. This is, as I said, is contained in Section 46 of the Companies Act. Now, when we look at capitalization shares, this is Section 47 of the Companies Act. Basically, what that section says, I can go to it in the meantime. So basically, what that section says is for the existing shareholders, when the company issues capitalization shares, it says that it must be in proportion to the existing shareholding. For example, let's say I've got 10% worth of shares in company XY Limited, and then the company is issuing further shares. I can only take up to 10% of those shares. It's similar to what we spoke about, the preemptive rights. If you remember, with the preemptive right, it's the rights that the directors have when an issuing of shares is done, specifically in a private company. Where private company is issuing shares, it first gives the option to take up the shares to the existing directors according to the existing shareholding. If you remember, we did an example where the company was issuing 1,000 shares. There was a director with 35% existing shareholding. He could only take up to 35% or 350 worth of those shares. It's something similar to that when you talk about capitalization shares, but it's specific to the shareholders and not specifically to the directors, like preemptive rights. That will be basically what Section 47 of the Companies Act would be explaining there. And I'm just having difficulties in opening it. Let me just give it a second. Okay, so here I'll go through 47, section 47, subsection 1. Except to the extent that a company's memorandum of incorporation provides otherwise, the board of that company, by resolution, may approve the issuing of any authorized shares of the company as capitalization shares on a pro rata basis to the shareholders of one or more classes of shares. It's that pro rata basis, as I said, that's I've got 10% shareholding. Once the board has authorized a further issuing of shares that has been signed by the board, and the resolution has been signed, then I can buy with 10% of those, or I can buy up to 10% of those newly authorized shares of the company, and those would be those capitalization shares. And basically, that is what we talk about capitalization shares. Moving on to section 48, company or subsidiary acquiring company shares. We are given a summary in the study guide where it says, actually it's first asking a question, may a company buy back its own shares? And to note, this is not the same action as a company issuing shares to itself, which is prohibited. So here we're asking, in XY Limited, we have issued shares worth 100,000. Let's say we've got an option to buy back those shares. The question is asking, can XY Limited buy back those shares? And the answer is yes, but there are conditions. Definitely, it's different to a case where the company is issuing 10,000 shares. The company cannot, as a juristic person, buy those shares. That is prohibited. But to go on, it says here, yes, a company can buy back those shares provided that the requirements of Section 46, which are distributions, and those of Section 48 are met. It further goes on to say, which is now Section 48, the board may determine that the company should acquire a number of its own shares. However, the board decision must be approved by a special resolution. We will look at in the next page, next 2 pages, how do we pass a special resolution of the shareholders of the company if the company is to buy back any shares from a director or prescribed officer of the company, or a person related to a director or prescribed officer of the company. Basically, we need a special resolution if a director or a person related to the director or prescribed officer, if the company wants to buy back those shares, a special resolution must be signed. Further goes on to ask, may a subsidiary of a company buy the shares of that company? Yes, provided that no more than 10% in aggregate of any class of shares is held by all the subsidiaries taken together, and voting rights attached to those shares may not be exercised. Basically, with the first one, it says, let's say we've got this holding company. Below it, it has got 10 subsidiaries. What it says is, if a subsidiary wants to buy shares in the holding company, collectively, those 10 subsidiaries cannot own more than 10% shareholding. So basically, it would mean that if all the the subsidiaries are buying a share in the holding company, each could have relatively a 2% share in those, 1% share in that company, so that 10 of them will make that 10% and nothing more. So yes, a subsidiary can buy shares of the holding company. Number one, as long as they do not have more than 10% aggregate shareholding, and that the rights to vote may not be exercised. That is a requirement according to Section 48 2B. 48 2B is this section here. So we've got Section 48, here's subsection 2B. Any subsidiary of a company may acquire shares of that company, but not more than 10% in aggregate of the number of issued shares of any class of shares of a company may be held by, or for the benefit of, all of the subsidiaries of that company taken together, and no voting rights attached to those shares may be exercised while the shares are held by the subsidiary and it remains a subsidiary of the company whose shares it holds. Basically, what is just being said there. And you are asked to start is section 46 and 48. 46 is regarding distributions, and 48 is regarding a company or subsidiary acquiring company shares. That is all regarding section 48. And looking now at the governance of companies, that is section 57. I will still have the Companies Act open should I need to make reference to it. Just I'm paging through to section 57. So section 57 is part F, which talks about the governance of companies, interpretation and restricted application of part. Just checking if I don't have any messages. Okay, no messages as yet, so we're still good. Okay, so firstly we'll start with section 57, where we'll talk about shareholders and voting rights. It first starts off by saying, take note that the shareholder is entitled to exercise any voting rights in relation to the company, irrespective of the form, title, or nature of the securities or shares to which those voting rights are attached. Furthermore, Section 57 provides for the way in which voting rights will be exercised in instances where, in a profit company other than a state-owned company, there is only one shareholder or only one director, and another instance where every shareholder is also a director of the company. So basically, Section 57 is saying that if the company is a profit company and there's only one shareholder, Section 57 does give an explanation of how the voting rights will be exercised, or in an instance where every shareholder is a director of the company, how is that going to be done. Also provides that the governance requirements in sections 59 to 65 do not apply where a profit company has only one shareholder. We'll look at those, section 59 to 65. For example, the requirements for notice, quorum, and conduct in meetings will not apply. So if you are a private company, there's only one director, there will be no need to meet requirements for a notice, quorum, or the conduct at meetings. And we'll look at those when we go along. So just to give a summary on section 57, according to the Act, a shareholder means a person who is entitled to exercise any voting rights in relation to a company, irrespective of the form, title, or nature of the shares to which those voting rights are attached. If a profit company other than a state-owned company is only one shareholder, and it just gives confirmation of what I've read through there, shareholders and voting rights. But basically with shareholders and voting rights, as a shareholder, you do have a voting right in accordance to the type of share that you hold, and one share is equals to one voting right. Looking at proxies, quorums, notice of meetings, and conduct of meetings, this is from section 58 to 64. And we'll be looking at specifically the Act. And let's start by section 58, where we are talking about the shareholder right to be represented by a proxy. So basically what section 58 says is, or firstly, let me bring on the concept of a proxy. So I'm a director of a company, however, or I'm a shareholder of a company, and there's a general meeting that is going to happen tomorrow, but it so happens that I will not be able to attend that meeting, but I want to exercise my voting rights in that meeting. Then I can appoint a proxy to represent me in that meeting. There are requirements for a proxy. I will read through them there by subsection 2, but I'll first start off by subsection 1. At any time, a shareholder of a company may appoint any individual, including an individual who is not a shareholder of that company, as a proxy to participate in and speak and vote at a shareholders meeting on behalf of the shareholder, which is myself. Give or withhold written consent on behalf of the shareholder to a decision contemplated in section 60. So basically, a proxy is myself just being represented by someone else. provided that the shareholder may appoint more than one proxy to exercise voting rights attached to different rights attached to different shares held by the shareholder. So if specifically I've got a share that has got a voting right, then I can appoint a proxy specifically to that share that I have. A proxy appointment must be in writing, dated, and signed by the shareholder. This is me now confirming this proxy, and remains valid for 1 year after the date on which it was signed, or any longer or shorter period expressly set out in the appointment. So I could say in the appointment, I'm expressly appointing this proxy just for this one meeting, or unless it is revoked in a manner contemplated in subsection 4C, which is below, or expires earlier as contemplated in subsections 8D. As an example, let's look at subsection 4C. 4C says if the appointment is revocable, meaning that it can be corrected or nullified, or making a later inconsistent appointment of a proxy and delivering a copy of the revocation instrument to the proxy and to the company. So generally, how can I revoke or reduce the time that I've appointed this proxy? I can, in writing, make an appointment to confirm that I am, stopping this proxy in acting on my behalf. I will need to send that. I can send that to the proxy and to the company. Actually, both of them will need to know that the proxy that you can no longer represent me, and the company notifying them that I will not be represented by this proxy. And basically, in a nutshell, that is what a proxy is. Also, the memorandum of incorporation could be specific to a company to say, for example, if you appoint a proxy, it must be someone not related, is not a supplier to the company. If you can imagine, if for example a decision is going to be taken, which suppliers are we going to remove from our panel, and you and I as a shareholder ask one of the suppliers to sit in that meeting, there might be a conflict of interest there. So a memorandum of incorporation can have, a clause that would basically say that you cannot select someone who is of interest or is a supplier to the company. Looking at section 59, record date for determining shareholder rights. So with this section it's saying that on the date it was recorded, who has shareholder rights. Now this would be rights to voting. So for example, let's say we have a meeting today and it is recorded that specifically these type of shares, you do have voting rights. For these shares, you do not have voting rights. Now, when a meeting or a shareholders meeting is held and voting needs to be done, they will always look at the record date of the shareholder rights. Specifically, this shareholder wants to vote on this, let's say, decision that needs to be made. Do they have the mandate or the right to vote in that meeting? And that's when then they will look at the record date, sort of like a resolution of a previous meeting that was held to confirm, if this type of shareholder would have voting rights. There are also what to call this now, conditions. For example, in subsection 2, a record date determined by the board in terms of subsection 1 may not be earlier than the date on which the record date is determined, or more than 10 business days before the date on which the event or action for which the record date is being set is scheduled to occur, and must be published to the shareholders in a manner that satisfies any prescribed requirements. So what basically says is, when a record date is determined by the board in terms of subsection 1 above says the board of a company may set a record date for the purpose of determining which shareholders are entitled to receive notice of a shareholders meeting, participate in and vote at a shareholders meeting. Basically, all those things that I've said earlier. So number 2 says that a record date determined by the board in terms of the above may not be earlier than the date on which the record date is determined, meaning that for example, to receive a notice of a shareholders meeting, it must not be more than 10 days before the date on which the event or action. So if let's say today was a Monday, and then there is a meeting that will happen in the next 10 days. Specifically, you will not be able to vote because it will still be within that 10 business days or an earlier date that would have been stipulated by the board. So that is will be basically record date keeping. Most importantly, it's a record date or a meeting or resolution that was previously held where the items noted in subsection 1 have been discussed. As I said, for example, who will receive notice of a shareholders meeting, who will participate in and vote at a shareholders meeting. Looking at section 16, shareholders acting other than at a meeting. It says here, a resolution that could be voted on at a shareholders meeting may instead be submitted for consideration to the shareholders entitled to exercise voting rights in relation to the resolution and voted on in writing by shareholders entitled to exercise voting rights in relation to the resolution within 20 business days after the resolution was submitted to them. So basically what subsection 60 says is a resolution or a determination can be made even though there was no physical shareholders meeting. Subsection 1 says a resolution that could be voted on at a shareholders meeting may instead be submitted for consideration to the shareholders entitled to exercise voting rights in relation to the resolution. So, for example, let's say it was resolved that in a shareholders meeting it would be resolved like on a decision that needs to be made, but in this instance, the shareholders do not physically sit in one room and decide on those decisions that they need to make. What could be done is, number one, depending that as a shareholder you've got a right to vote, you can send a resolution. Let's say, for example, it was noted in a previous meeting, shareholders meeting, that we needed to we after receiving a proposal to mine oil in Saudi Arabia, we gave the shareholders 10 days to decide on that. But now instead of actually having to sit again and make a decision on that, if you are a shareholder that has got a voting right, you can submit a resolution or consideration to confirm or to confirm that you are agreeing that the company should go and mine oil in Saudi Arabia, or you are against that. So basically, shareholders acting other than at a meeting is you are making a decision that would have been made generally in a shareholders meeting, but you are not sitting physically in one room or having, let's say you are having that shareholders meeting remotely, let's say via Zoom or via Teams. You are not having that type of environment in making the decision, but the shareholders submit documents or resolutions on their own behalf to the board, confirming of the right or the way that they want the business to continue. Also, number two, maybe to make mention, voted on a resolution that is voted on in writing by shareholders entitled to exercise voting rights in relation to the resolution within 20 business days after the resolution was submitted to them. If I could make another example, if you do belong to a medical aid, generally towards the I think it's towards the end of the financial year end or beginning of the new financial year. They would send a meeting of an annual general meeting where they would give, give an agenda of what needs to be proposed or what needs to be decided on. And I think depending on the medical aid, maybe they would say that as a member of that medical aid, you've got one voting right. For example, you can vote on who the principal or the chief medical officer will be if it's a case of a medical scheme. Um, so after after that after that resolution, or after, let's say, the AGM now has been held, you will be given 20 business days to submit your decision. So you can submit a decision, say yes, you are agreeing to appoint this chief medical officer, or you are against in appointing this chief medical officer. As I said, it's all dependent on the medical scheme, as an example. Looking at shareholders meetings, this is section 61. The board of a company or any other person specified in the company's memorandum of incorporation or rules may call a shareholders meeting at any time. So the board of a company or any other person specified in the company's memorandum of incorporation, for example, let's say a secretary for Zuko's Pty Ltd is not regarded as a director to be part of the board of directors, but the memorandum of incorporation could stipulate that a company secretary has got the right to call on a shareholders meeting. Remember, company secretary is generally the face or the brains, of the company, meaning that generally she knows everything that happens in the business. So memorandum of incorporation could have a clause to say that a company secretary can call upon a shareholders meeting. Subject to section 60, a company must hold a shareholders meeting at any time that the board is required by this act or the memorandum of incorporation to refer to a matter to shareholders for decision whenever required in terms of section 70, subsection 3, to fill a vacancy on the board, and when otherwise required in terms of subsection 3 below, or 7, or by the company's memorandum of incorporation. Let's look at subsection 3. Subsection 3 says, subject to subsection 5, which is below, and 6, the board of a company or any other person specified in the company's MOI or rules must call a shareholders meeting if one or more written and signed demands for such a meeting are delivered to the company, and each such demand describes the specific purpose for which the meeting is proposed, which is the agenda. In aggregate, demands for substantially the same purpose are made and signed by the holders as the earliest time specified in any of those demands of at least 10% of the voting rights entitled to be exercised in relation to the matter proposed at the meeting. So basically,
Hi, Zogo.
when yes,
Hi, sorry, can I disturb you for a second? I want to go
yes, you
back
may.
to the point where you said like what happened. There can be a resolution of shareholders where there's no physical attendance on the matter. So what happened? Each and every shareholder, according to their voting rights, they submit a resolution. There is more like a get posted to the company and on the or about the matter. And then what happened? It went to the secretary of the company. So whatever popular vote, so that popular vote will be taken as an action for that resolution.
Yes, that is correct. That is correct. So when a resolution or a proposal to a decision is being made, now according to the type of shareholder you are, in conjunction with the voting rights you have, once you've made a vote on that, you need to submit it. So part of the proposal being made, it also needs to specify where exactly you need to send through your submission. So let's say, for example, there, as you said, the proposal would say your submission must be made to the company secretary so and so at this email address or at this postal address, for example. And then when you are making your submission on the decision, you need to provide it or to send it specifically to that correspondence, or in this instance, the company secretary. It can further on to say, let's say the memorandum of incorporation could also stipulate that um, you need to provide it in electronic form, meaning that you need to send an email, like it must be a signed email. Because if you think about it now, let's say with the COVID, the memorandum of incorporation says it must be done via post because they want to see your physical signature, like the wet ink on the letter that you would have signed, you know. But if you think about it, it would actually not be viable because, you know, with COVID everything is happening slow, so you might not get the confirmation within time. Let's say if it's posted, you need to post it within 10 business days, meaning that when you send it to the post, it must be stamped 10 days before. Sorry, it must be within 10 days after that proposal was done. But it can only be received by the company a further 20 days later, and by that time it might be late. So the MOI could also be specific to say that in a case where it's not foreseeable to do this in writing, you need to send, sorry, to do it via post. You can also send an electronic copy of your decision. It can also stipulate that.
So in that scenario, what will happen? There will be more like the resolution that we're voting on, although we're not attending the matter in person, and then there will be more like timeline, and then
Yes.
all the stakeholders will be informed about the decision that has been taken regarding the
Yes.
matter that was on hand.
Yes, that is correct. So the first part is, as I said, let's say a physical meeting was held. This is what was discussed. These are the timelines for everyone to do their own research. Within 10 days after receiving that proposal, you need to give your response. It must, for example, via email. It must be sent to the company secretary. Now, depending on what needs to be decided on, it could either be an ordinary or a special resolution, and that is what we are going to look at now on page 37. When do we need or how do we pass an ordinary resolution? When do we pass a special resolution? That is what we look at on now. So yes, the results of that needs to be passed as well. Just like, for example, in a notice of when if there's a meeting and a decision is being made, part of the notice, part of the minutes of the meeting, it needs to be confirmed that 10 people were against the company mining in Saudi Arabia, and 20 were for. That needs to be noted there. So that also needs to be done as well. Also, what the company could do is also provide a what to do next. So yes, people have, or the shoulders have confirmed that they want us to explore oil in Saudi Arabia. These are the next steps. For example, service provider needs to be appointed in Saudi Arabia, because we can't take our equipment in South Africa and deliver them or transport them to Saudi Arabia. So there will also be a timeline of those things as well, but they'll all be dependent on what the decision has been made. Are we continuing, or are we going there, or are we not? And it'll just depend on that specific company. So yes, you are correct.
Okay, thank you, Subo.
Thank you. And I think I just forgot where I was. I think I was here.
The shoulders
Shareholder,
meeting.
yes, shareholders meeting. So yes, I was confirming shareholders meeting. Board a board member could call a meeting. Company secretary, depending on the memorandum of incorporation, can also call a board meeting. Let's say so part of, depending on the company, the CEO, the chief investment officer, the chief information officer, the chief operations officer, the MOI could stipulate that those are directors of the company, so those people would have the right to call a meeting. If, for example, it could also go on to say, if you are a shareholder that owns more than 10% or 20% of the shares in the company, you can also call in a meeting. That could be a case of, let's say, for example, it's a family business where, let's say, the family still, controls, let's say, 51% of the company. It goes also stipulate there that, as I said, the majority shareholder can call on a meeting, or the first incorporators have got the right to call a meeting. So it all depends on the company. Specifically looking at the shareholders meeting, in relation to the when can a meeting be convened, so this will also be stipulated. The act will stipulate also the company could have a date as well to say that, for example, for annual general meetings, we need to hold, or sorry, in the MOI, we need to hold an annual general meeting on the 11th month of each and every financial year. That will also be specific, but as long as it's in line with what the Companies Act is saying. For example, if you look under Section 7, it says a public company must convene an annual general meeting of its shareholders initially no more than 18 months after the company's date of incorporation. So our business or our company was incorporated on the 1st of January 2020. We need to hold an annual general meeting by June 2021. That is within 18 months after the company has been incorporated. Thereafter, once in every calendar year, but no more than 15 months after the date of the previous annual general meeting or within an extended time allowed by the company's tribunal on good cause shown. So basically, companies incorporated within 18 months, you need to have a shareholders meeting. After that, you need to have a shareholders meeting every calendar year, no more than 15 months apart. So let's say, for example, for some reason, um, you hold the annual meeting in month 12, but let's say, for example, there was something had happened that you could not convene that meeting, that will be 12 months. You've got an extra 3 months to hold that annual general meeting. So basically, an annual general meeting could also be after the financial year end, as long as it's within 3 months after that financial year end of the company. Also within that calendar year. In the calendar year, let's say your company is from Jan to December. Within Jan to December, you must hold a meeting. If not, you've got up until March the following year to hold that meeting. What could be contained in a meeting? Presentation of the director's report, the audited financial statements, immediately preceding the financial year, an audit committee report. Also, in the meeting, an election of directors could be done to the extent required by this act or the company's MOI, an appointment of an auditor for ensuring the financial year, and an audit committee, and any matters raised by shareholders with or without advance notice to the company. So generally, those are the things you can read up on what could be discussed in a shareholders meeting. Notice of meeting. So as I said earlier, number one, that would be um, a, a notification of an annual general meeting that needs to be held. Let's say now for our company, this is done the month after the financial year end. Let's say it's from Jan to December. In Jan, we are having our annual general meeting. Notice will be sent to all the respective shareholders. The shareholder meeting is held, decisions are made, and notice of the meetings need to be distributed to the shareholders. Section 62, subsection 1, the company must deliver a notice of each shareholders meeting in the prescribed manner and form to all of the shareholders of the company as of the record date for the meeting at least 15 business days before the meeting is to begin, in the case of a public company or a non-profit company that has voting members. So with this one, it's not the um, notice of minutes to a meeting, it's the notice of the meeting. So you are giving the shareholders notification of a shareholders meeting that is going to be held. So for a public company, you need to notify the shareholders within 15 business days before that meeting happening. It's 10 business days before the meeting to begin in any other case. So for a private company, you need to notify the shareholders 10 business days before the meeting is to begin. A company's memorandum of incorporation may provide for longer minimum notice periods than required by subsection 1. So that is all dependent on the memorandum of incorporation. Subsection 3. A notice of a shareholders meeting must be in writing and must include, now coming back to what we spoke about earlier, the date, the time, and the place for the meeting, and the record date for the meeting, the general purpose of the meeting, which is the agenda, and any specific purpose contemplated in section 61.3a if applicable. So basically, you need to detail what will be discussed in that meeting. A copy of any proposed resolution of which the company has received notice and which is to be considered at the meeting, and a notice of the percentage of voting rights that will be required for this resolution to be adopted. For example, with the first part, we have proposed a resolution to start mining in Saudi Arabia. We can provide a resolution or to say that, look, we are intending to mine in Saudi Arabia. Then in the meeting, you will talk about that. Also, you need to specify or to consider what type of resolution will be needed for the types of decisions that needs to be made. Is it an ordinary resolution or a special resolution? Hence, it says that a notice of the percentage of voting rights will be required for this resolution to be adopted. You don't want a case where you are holding a meeting, you only have a certain percentage of the shareholders, but you actually need, 75% to pass a special resolution. And you can read up all on the other information. It's more, what is contained in the notice of those meetings. Conduct of meetings, this is the second last one before we finish the sections. Conduct of meetings. Before any person might attend or participate in a shareholders meeting, that person must present reasonable, satisfactory identification. So Zuko, as much as, I would assume that everyone in the board knows me, but I need, the act requires that you need to present yourself, you need to present your identification, and the person presiding at the meeting must be reasonably satisfied that the right of that person to participate and vote either as a shareholder or as a proxy for a shareholder has been reasonably verified. So I cannot, for example, appoint a proxy to say that they must go and vote for me, but I don't have any voting rights. If I'm invited to that meeting just to listen, that is what I need to do. I cannot vote on that meeting. So the presiding officer, the mandate is on him or her to make sure that whoever is voting, whoever is a proxy, do have the legal right to, to share in the decision making. And section 64, meeting quorum and adjournment. I remember I got a question last time. I just can't remember who the student was, where she made mention that she read a part where it was talking about how many directors are needed to meet a quorum in a meeting. We will touch on it also when we do directors in the next session. Sorry, in the next session, which is will be directors. But basically, it says here, a shareholders meeting may not begin until sufficient persons are present at the meeting to exercise in aggregate at least 25% of all the voting rights that are entitled to be exercised in respect of at least one matter to be decided at the meeting. So basically, you need at least 25% of the people who've got voting rights in a meeting to start a meeting. A matter to be decided on may not begin to be considered unless sufficient persons are present at the meeting to exercise at least 25% of all the voting rights that are entitled to be exercised on that matter at the time the matter is called on the agenda. MOI may specify a lower or higher percentage in place of the 25%. But where I want to get to is, despite the percentage, this section here, despite the percentage figures set out in subsection 1 or any applicable provisions of a company's MOI, if a company has more than 2 shareholders, a meeting may not begin or a matter begin to be debated unless at least 3 shareholders are present at the meeting. So for every, if there are more than 2 shareholders, we need at least 3 shareholders. The requirements of subsection 1 of the MOI, if different, are satisfied. So Either you need to meet the 25%, or you need to meet of, if there are more than two shareholders, you need at least three shareholders to be present in that meeting. If within 1 hour after the appointed time for a meeting to begin, the requirements of subsection 1 or 3 above applicable for that meeting to begin have not been satisfied, the meeting is postponed without motion, vote, or further notice for 1 week. So basically, if you have not met the quorum, you need to suspend the meeting for 1 week. For consideration of a particular matter to begin have not been satisfied. If there is other business on the agenda of the meeting, consideration of that matter may be postponed to a later time if the in the meeting without motion or vote. For example, where you specifically need, to meet the quorum to make a decision or a resolution to make a decision on some point, you'll rather have to postpone the meeting than actually make it null and void in voting on a motion. If there is no other business on the agenda of the meeting is adjourned for 1 week without motion or vote. So in a case where specifically we're going to talk about us exploring oil in Saudi Arabia, the quorum has not been met, then the meeting needs to be adjourned for 1 week without motion or voting. So that is now to make sure that all the respective shareholders are there to meet the quorum for the meeting to start. And that was section 64, and that was looking at proxies, quorums, notice of meetings, and conduct of meetings, and that was detailed from page 35 till page 37.
I
Lastly,
just want,
looking at, yes.
I just want to ask you about the quorum. As a quorum, there's a specific percentage that need to be met according to the numbers of the people. Like, e.g., if there are seven directors, how many, like, what's the percentage of those seven directors in order the meeting to be valid?
Okay, let me make page reference where we'll talk more about that. If you can turn to page 50
To
of the
page
study
50.
guide. Yes, everyone, you can turn to page 50 of the study guide. Section 4.2.2, board meetings or directors meetings. It says section 73 provides that a director authorized by the board may call a meeting of the board at any time, must call such a meeting if required to do so by at least 25% of the directors if the board consists of at least 12 members, or two directors in any other case. So if you remember, we also did make mention when I was going through the act. So this is sort of like in summary form rather than actually going back to the Companies Act. So basically what it says is if the board consists of at least 12 members, you need at least 25% of the directors to be in that meeting. For any other case, you need at least two directors to be in that meeting.
Okay, thanks.
Yes. But I can also give more clarity when we go there, and I think we will not have to have enough time to go through all of that today. But let's continue. Okay, so we're still on page 7. Sorry,
Sorry,
30.
Zuko, can I also ask a question
Yes,
regarding to what
May.
you just said? From what we just read in the study guide, the
Yes.
two directors are included in the three shareholders that should be present at the meeting as said in section 64.3a.
So what that section says is if a company has got more than two, we need at least three. So if you think about it, if we're saying, let's say we've got more than two and we've got five, and you are saying we need at least one director to sign on a motion, you have not met what the act is saying. You have not met that majority, if you put it in simple terms. However, the Companies Act specifically says if you've got two, let me just go back to that section. That where's that section now? Sorry, I'm just looking for that section. Okay, but what that section says is if either you meet 25% if you've got at least 25 members, or if you've got more than two, could be 20, it could be 30, depending on the company, but at least you need three of them to be in that meeting. So remember, that is part of meeting the quorum. There is a difference in signing or signing on a decision, and that is part of the shareholders resolution, where if, for example, for ordinary resolution, we would need at least 50% of the people who've got voting powers to sign on or to decide on a decision. We need at least 75% for a special resolution. So what we've just covered now is, in a meeting, how many people should we have? If we've got at least 12 members, we need at least 25%. If it's more than two, we need at least three. I hope I did try to give clarity or to answer that question.
Yeah, okay, thank you. It's fine.
Okay,
Sorry, Zuko.
maybe yes.
One more time on that space, still on that section. So it says if there are 12 directors, at least 25%, which means it's three. So in any other matter, which is from 11 to 5, which means two directors must be present in order the meeting to be valid. Is that correct to assume that?
Sorry, repeat the last part. Yes, the first part is correct. Repeat the last
Uh,
part. I just did not. Please
From
repeat the last
11,
part.
like I'm making example from 11 directors to 4 directors. It's safe to assume, as they say to any other matters, two directors must be present in order the meeting to be valid. So from 11 to 4 directors, only two directors must be present in order the meeting to be valid.
Three directors. So it says there, if there are more than two. So let's say in this instance, it's more than two. Let's say we've got 11 directors. We need at
Yes.
least three. We need at least three.
So what about that other matter? They say two
Sorry.
directors in two directors. Remember the second part of it.
Oh
The second of they say 25%, and then the second part they say any two directors.
no, sorry. Apologies. It's me. So it says there, if we've got at least 12 members, we need at least 25% of the directors. If it's more than three, sorry, if it's more than two, meaning it could be 3, 4, 5, 6, 7, up to 11, we need two directors. Yes, we need two directors. Sorry, I just said my numbers mixed up.
Okay, thanks, God. Just
Yes,
want to make sure of that.
yes. Okay, thank you. So still page on 37 now. This is also a question that was asked last week. So for an ordinary resolution, or actually what it entails, in terms of the definition given in section 1, that was just explaining what an ordinary resolution is. It says an ordinary resolution means a resolution adopted with the support of more than 50% of the voting rights exercised on the resolution, or a higher percentage contemplated in section 65.8. So basically, for ordinary resolution, you need at least a minimum of 50%. But for a special resolution, you need at least 75% of the voting rights. Also, one thing to note there, which is on top of page 38, a different percentage of voting rights, sorry, a company's MOI may permit a different percentage of voting rights to approve any special resolution, or one or more different percentages of voting rights to approve special resolutions concerning one or more particular matters, respectively, provided that a margin of at least 10 percentage points must be maintained at all times. So basically what it says is, the Act says you need at least 50% to pass an ordinary resolution and at least 75% to pass a special resolution. If the company's MOI amends those resolutions, for an ordinary, they would say we need at least 60% instead of 50. The special resolution will be 75%. Now, the difference between the two resolutions, is it a minimum of 10%, a difference of 10 percentages? The answer is yes. But if, for example, the MOI says for an ordinary resolution, we need 70% to pass, and then the special resolution still stays at 75, then you cannot do that, because it says the act at any given time, there must be at least 10% difference between passing an ordinary and a special resolution. I hope I've got that clear. Okay, I'll assume that is clear, and then you can just read up upon below that when is a special resolution needed. For example, it's needed to amend the company's memorandum of incorporation to the extent required by section 16.1. For example, the reason why we've got that one as an example, amending the MOI is not something that is part of the company's operations. That could happen once every year, once every fifth year. It could not even happen, for that matter. But should the need arise to change the memorandum of incorporation, that's when you would need a special resolution, meaning that 75% of the board would need to sign that off. Let me check on the time. It's 3:53. Okay. That's fine. So what I will do is I will touch on a bit on the first two sections of directors before we adjourn for today. But basically what we will look at now for today, we're looking at this is on page 42 of the study guide, looking at the board, directors and prescribed officers, election, ineligibility and disqualification, and vacancies. And we'll also look at Learning Unit 4.2, board committees, meetings, and directors acting other than at meetings. This will just be basically, a repeat of what we just covered. Firstly, what I want to make a reference to on page 44, there's a table that talks about the required numbers for directors. So depending on the type of company, how many or what is the minimum of directors that is needed. For a private company and a limited incorporated company, we need a minimum of 1 director. For a public company, state-owned company, or a not-for-profit company, we need at least 3 directors. There's nothing more really I could give on that. Also, remember, this is what the Act is prescribing. So the MOI could also be specific to say, in addition to what the Act is saying, we are requesting, let's say, instead of 3 minimum directors, for our type of company, we need at least a minimum of 5 directors. Also, one thing to note, a director's remuneration for services as a director must be approved by a special resolution adopted within the previous 2 years. So if the MOI would say that, MOI would say that the board would need to determine the remuneration for the directors, looking back previously what had been decided on as remuneration for a director, then that would be the case. However, for the future, they can stipulate that, let's say, for example, they would say every second year, we need to revisit the amount that we pay our directors, and then it can be changed. I don't know which formula they use, unfortunately. But looking at something very important, the election and removal of directors, and we will do. Yes.
Are we still on the topic of directors? I just want to ask you something.
Yes.
We're still speaking about remuneration of directors.
Yes.
Is the act specify? Remember the two categories of directors: the executive and non-executive one. Does the act
Yes.
specify the qualification of both executive and non-executive? Who can hold the office? Who cannot hold the office?
Okay, not that I specifically am aware of, but I will write that down as my task to do, to specifically look at the Act if there is a prescription specifically with the qualifications, remuneration. But I do know, like, for example, let's say, remember this Act was done in 2008.
Yes.
The Commission Tribunal could not have foreseen that, in 2020, this is what the remuneration for a director should be. Like, we can be honest, they would not have seen that. Also with the prescription, for example, they could specify that for, for qualifications, that director needs to have the knowledge, the skills, and expertise, to be part of a director in that company. Yes. Also remember, what happens is, as I said earlier, a CEO, a head of department, can also be noted as a director. That is a person who is an expertise in their own field. So by virtue of being, made head of department, you are sometimes,
Qualified.
made part of the board of directors. So that could be something the act would prescribe to say, look, the person must have the skills and knowledge to be in that industry, or maybe not specifically in that industry, but have the expertise to be in that, to be a director. Then it will be dependent on the company hiring that director. For example, an engineer, or sorry, an engineer are sometimes, appointed as, or an engineer can become a a chartered accountant, because of the knowledge, the skills, the training they have, while they actually becoming engineers. So that could be another example. So you cannot specifically say that just by virtue of being an engineer, you cannot become a chartered accountant. So it will also depend on the company. The act could specifically say, as I said, you need to have the skills, you need to have the experience, you need to be a tenured, member or a director. But with remuneration, it could also speak on maybe the term on how long you could be a director. But I do definitely know what will cover is when can you not become a director. For example, if you are accused of fraud, if you are a delinquent director, those things there. But let's look at diagram 4.1.2. Maybe I will
Right.
answer some of your questions, and then we can call it a day, and then we can finish anything else in the next session. So as I said, we'll be looking at the election and removal of directors. This is from section 67 to 71 of the Companies Act. Remember, incorporators are the first directors of the companies. This was section 67.1, and will serve until sufficient other directors have been appointed. So if you remember, in my instance, I'm the director. I'm the one who decides, okay, look, let me come up with this company or register this company. Now I've got funding, I've got everything that I needed to start with the company. So when then I ask my friends to become the board of directors, in that instance, that is that appointment of directors. Looking at the appointment of directors, when can you not become a director? Section 69.7, a juristic person, meaning a company, an unemancipated minor or under a similar legal disability. As you know, in South Africa, if you are a minor, you cannot sign on your own. A person not meeting the requirements of the memorandum of incorporation, if any. For example, there might be stipulation by the board of directors in the MOI that you cannot become a director. Let's say, for example, if you had previously worked for the competitor, But when can you become a director? If you are elected by the shareholders, it's voted on separately, you serve for indefinite term or as set out by the memorandum of incorporation. But when can you be disqualified, meaning that you have been appointed, but now you are being disqualified? If you are prohibited by a court, if you are declared delinquent by a court, that would be, for example, if you remember in the case of Tutumieni of SAA, she was declared by the court as a delinquent director, and she was registered in the, I think it's also called the REDS register, sort of like a register kept for disqualified, directors or representatives, where, because of fraud and corruption. An unrehabilitated insolvent, so you were insolvent and there was just no way that you are rehabilitated, and also you cannot be appointed a director if you can handle your own affairs. Prohibited in terms of public regulation, if there's a specific public regulatory act that bars you. Removed from office due to misconduct that involved dishonesty. Remember when we spoke about the duties or responsibilities. Actually, part of the things we spoke about, you need to be honest, integrity, objectivity. If you are convicted and imprisoned without option of a fine for theft, fraud, forgery, perjury, or other offenses. So if you were in jail and you weren't given a fine, then you are disqualified to be appointed as a director. Note, the Memorandum of Incorporation may set out additional grounds for ineligibility or disqualification dependent on the company. Now, looking at when can you be removed as a director? You may be, and this is section 71, you may be removed by ordinary resolution unless stated otherwise in the Memorandum of Incorporation. You must be given notice of the meeting and a resolution to remove him. So you as a director or the director to be removed, you must be given notice of the meeting, and part of the agenda should be the discussion of you being removed as the director, and you must be given the resolution or confirmation that the board has voted against you becoming a director. And also you must be afforded the opportunity to make a presentation to that meeting before voting takes place. Remember, guilty until proven innocent, and also we are all equal before the court. So hence you need to be afforded the opportunity to appear. When ordinarily can you be removed? Where a shareholder or director alleges, where a shareholder or director alleges that a fellow director, this is also section 71, has become ineligible or disqualified. Let's say, for example, you work for an accounting firm. Part of you being a chartered accountant for that firm, you are regarded as part of the board of directors. But for some reason, because of something that you have done, SAICA has removed you as a chartered accountant or stripped you of your designation, then a shareholder has got the right to report you that you have become ineligible or disqualified from the profession. You are incapacitated to perform as a director. For example, let's say maybe you're in a coma and you never came back, you can't sign on your own, or you neglected your duties, or you have been derelict as a director. So basically, we're just not doing your work and there's no need to keep you as a director. What must be done? The board must consider these allegations. The board may vote on the removal of you as the director. The director may not vote on your removal. So if an unanimous decision needs to be made, let's say it's 50-50, you cannot vote on yourself to say, look, you want to stay. The director must still be given notice and an opportunity for representation, so you can even get a lawyer. The director may apply within 20 days to court for a review. So this is after you being removed, you've got 20 days to apply to the court for a review. Note, this cannot apply to companies with fewer than 3 directors. So for example, if it's 2, one is voting for you to be removed, one is voting for you to not be removed. Does not apply in that case. That will just be a decision that most probably will have to be contained in the Memorandum of Incorporation, like in a case of where what needs to be done, should there be, the voting should be equal. Also in a case where there's only one director, you as the one director, you cannot vote yourself out. It's either you continue or you don't continue becoming a director. And that will be all, folks, for today. So just to confirm, for next week, we'll just continue with Learning Unit 4.2, which is on page 49, and also Director's Personal Financial Interest, which is on page 52. And lastly, we'll look at the director's conduct, liability of directors and prescribed officers. To finish off, before we start, the next session will be enhanced accountability and transparency. As I said, we are not having a session next week. We'll have a session on the 3rd of October to cover the next topic. Any questions before we're done for today?
One question, Zoko, for you.
Thank you.
About the appointment of directors. Just want you mentioned something about the register. What happened if the director was removed from the previous post because of reckless trading? And then what happened? Does the director get the register, get his name on that register? And what happened if the new company wants to appoint that director that maybe, let's say, 18 months ago was dismissed of reckless trading? Do they pick up that information?
So I do not have specifically a straight answer on um, if they can revoke, a director being on that REITs register. So from what I do know in being a representative before, you are noted in that register for something that is confirmed. It's not allegations, it's something that has been confirmed that you have done. Let's say, for example, with Tutumieni, look, there were court proceedings, there was the Commission of Inquiry, the EFF, not actually talking about politics, but making an example, they made sure that, she was noted in that rates register. So I do not know now, you running your own company, wanting to appoint her, if you are debarred from actually appointing her as a director. However, that information is there for you to make use of. So if you are saying, look, I am appointing this director who has been accused of fraud, or actually even found by the court, was fraudulent, was corrupt, the owners would put you as a company in doing that. But I will also look at more information on the register. Like, for example, can you revoke, your director's name being there, and then we can have a discussion on it next week. So I don't have much information on how that part goes, but it was generally knowing that there is that type of register.
Okay, thank you, Zuko.
Yes, thank you. I'll make note of it. And also, guys, just to confirm again, I am still having issues in pasting the link to the register and also to the feedback form. Apologies for that. If there aren't any further questions, you're more than welcome to log off. I'll also be stopping the recording and stopping the presentation as well.
Hi, Zuko. I have one or two questions for you.
Yes.
I just wanted to know about the, I think Olu to ask something regarding the shareholders acting other than at a meeting. What I
Yes.
wanted to know was, let's say there is a shareholder meeting held, right? But there is a shareholder that cannot make it to the meeting, or let's say there was a notice for a meeting to take place, but there's a shareholder that knows that they cannot make it to the meeting, and there's a vote that will be happening at the meeting. Can then the shareholder that won't be making it to the meeting send through the documents needed regarding their own decision?
So when we spoke about the shareholders acting other than at meetings, it's exactly that last part that you've said there. So we said shareholders acting other than at meetings is a, a resolution has been passed, meaning that, let's say, we have sent through a communication then that we want to explore mining for oil in Saudi Arabia. But now, instead of us actually calling a meeting to give a yes or a no, we're sending that communication to the shareholders, and in return, the shareholders will be sending their responses back to the company. As I said, that notice could even say that you need to submit your responses to the company secretary at this email address, or since it needs to be in writing, specifically at this email address, or maybe via post at this specific postal address, or deliver to this business address of the company. So shareholders acting other than at meetings is a shareholder giving a response or making a decision where they have not physically sitting in a meeting or in a shareholders meeting. That is what we meant, shareholders acting other than at meetings. You are making a decision that you are not sitting in at all at once, but the decision would stay as if you are all sitting in one room. Just imagine now, just calling a meeting to ask for a yes or a no. That one would see it as if a waste of time. However, also depending on the complexity of what needs to be done. If it's just a yes or a no, should we do research on mining in Saudi Arabia? Yes or no, that will just be sufficient to send in your response. And then, as I said, listen, now you have given your response, the exploration has been done, then another meeting now would be called to give the findings that yes, this is viable, this is not viable, then a special resolution would need to be passed.
Okay, thank you. And my final question was regarding the subsidiary owning a share of a holding company.
Yes.
Was it so let us say there are three subsidiaries under a holding company, and one of them decides not to have any does it okay, what I actually want to ask is, does it have to be distributed equally amongst the subsidiaries,
No.
or can
So
okay.
in your example, we've got the holding company, we've got three subsidiaries. The one subsidiary decides that I'm going to buy 10% of the shares in the holding company. The next two subsidiaries cannot buy shares in the holding company because the first company already has got the maximum percentage that they can hold. So it can also go via that way. It doesn't need to be split equally. Remember, the onus is always on the subsidiary if they want to own part of the holding company. If, for example, the one company buys 2%, the other one buys 5%, the third one can only buy 3% as long as it does not exceed 10% shareholding.
Okay, thank you.
Thank
I,
you for
I,
the
I
question.
will go. I will go on this question of Yolanda. Do other two get like do they get informed about the other company that want to buy all the 10, or does it get done in silent?
So depending on the company, it could be contained in a memorandum of incorporation. Let's say it's a big holding company with many subsidiaries. The MOI could basically say that when there's going to be an issue of shares, priority must first be done to the subsidiaries. Basically, in a way of doing that, you're trying to keep everything, controlled by this one big holding company. So the MOI could, say that, look, we must go and ask the public, offer the shares to the public. Or if it's a private company, remember, private company, you don't offer shares to the public. So that's when then in that instance you can, secretly, if I could use that word, go to the subsidiaries if the MOI does allow that, to say, look, we've got X amount of shares that we are offering to you as, collectively as the subsidiaries. If you want to take up, this is a process you need to follow. So it all depends on what the memorandum of incorporation says.
Okay, thanks.
Yes, thank you. Any further questions? If not, thank you. Okay, let me just check here. I think there's a message.
Do you send the register for today?
I'm having issues in sending the register for today, unfortunately, but what I did is I made a screenshot of the participants just to serve as confirmation for this meeting. So apologies, when I do paste the link, it says failed to send, and this was the case with the previous session as well. So I don't have it for today, unfortunately, but I have tried to do something on my side just to provide proof that I did have the session, and also the recording is here as well.
Okay, thanks.
Thank you. Um, if there are any further questions, thank you very much. And I will be seeing you on the 3rd of October, where the lecturer, Adele Duprier, will be meeting us as well. Thank you very much, and do enjoy the weekend further.
Thank you,
Cheers,
Zuko.
bye.
Bye,
That was
everyone.
so useful.
Thank you.
Bye, guys.
Bye.
Bye.